What is Title VI? Title VI is a federal law which prohibits discrimination on the basis of race, color, or national origin. The law: no person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. A part of the Civil Rights Act of 1964. The Title VI of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, and national origin. The definition includes ethnicity classifications as well. Examples include, but are not limited to, African American, Caucasian, Latino, American Indian, Egyptian, Asian, German, Bengali, and more. Discrimination practices can include denying an individual any service, financial aid or benefits, providing a different service, aid, or benefit, or providing them in a manner different than they are provided to others, segregating or treating individuals separately in any manner related to receiving programs, services, or benefit retaliation. Limited English proficiency discrimination. Now let's go over the basics of Title VI compliance. Who is required to comply with Title VI? Any entity which receives federal financial assistance must comply with the provision of Title VI. This includes Tipton Prevents. What does compliance entail? Ensuring that the method in which programs or activities are delivered are such that no person is denied benefit of or access to those programs or activities because of their race, color, or national origin. Limited English proficiency provisions of Title VI covers discrimination on the basis of national origin because of language barriers, ensures equal access to benefits for persons with limited English proficiency, ensures that services are not delayed or denied because the service provider cannot communicate with clients because they do not speak English. Agencies must provide interpreters who are appropriately trained and can accurately translate either in person or on the telephone. Now that we've covered the basics, let's go over some examples of non-compliance. Obvious denial of services or the delivery of inferior service to individuals because of their race, color, or national origin. Engaging in differential treatment to individuals seeking to access services due to race, color, or national origin. Providing services but not providing the same level of information, customer service, etc. because of the client's race, color, or national origin. Denying access to membership of planning or advisory bodies which are integral to programs because of race, color, or national origin. Failure to provide information or education about program availability and eligibility to protected beneficiary groups. Failure to provide services or information in a language other than English when a significant portion of the potential client base have limited English proficiency. What is our responsibility and plan of action? Maintain Title VI compliance and delivery of programs in a non-discriminatory manner. Maintained federal funding for programs and service to taxpayers. Awareness of possible unintended actions which could result in non-compliance. And continued training and education about Title VI and its impact. What do you do if you feel that you have been discriminated against? Tipton Prevents has an inquiry, complaint, and grievance process that allows any service recipient to express complaints, concerns, or grievances in a confidential, non-threatening manner that ensures the issue will be addressed and a resolution will be made with the level of satisfaction of the complaint indicated. If you feel that you've been discriminated against, follow these steps. Write down a full account of the discrimination event. Include full details including names, times, dates, and location information. Contact one of the following within 180 days of the alleged discrimination: the Tipton Prevents Title VI Coordinator or the Tennessee Human Rights Commission. Tipton Prevents Title VI Policy Statement. It is the policy of Tipton Prevents to not discriminate against qualified individuals based on mental or physical disabilities. And Tipton Prevents will make appropriate, reasonable accommodations for any known disability that may interfere with an applicant's ability to compete in a selection process or employee or volunteer's ability to perform the essential functions of a job. All applicants, employees, consultants, and volunteers are expected to be able to perform the essential functions of the position with or without reasonable accommodation. It is the responsibility of the applicant, employee, consultant, or volunteer with a disability to inform the appropriate person that an accommodation is needed.